So I think we are clear about the first element of a contract, offer and acceptance. And that is, we've digested a little bit about invitation to treat and offer and, great. Now, the next one or the next element we are looking at is the consensus or mutual assent. Now, the consensus, which is otherwise known as meeting of the minds, is when both parties to the contract have a common understanding and agreement on the essential terms of the contract. This ensures that both parties understand each other regarding the contractual expectations and obligations. So if Mr. Amoa and any of my professors here are, engaging in any form of a contract, this element says that the two of us need to understand and agree on all the essential terms of the contract. If at some point there is a disagreement, then there can be no contract. So there should be that mutual assent, or what they say, meeting of the minds. The minds should meet. Okay. Now, to make this more meaningful, let's look at a case between Raffles versus Wichel House. Please, if I mention the name wrongly, you can't blame me. Raffles versus Wichel House, okay? What happened? They entered into a contract for sale of cotton, listen carefully, to be shipped from Bombay to Liverpool. The agreement specified that the cotton would arrive on a ship called Peerless. Listen. However, there were two ships named Peerless, each departing at different times. Raffles intended the cotton. Let me clear this thing off. Raffles intended the cotton to be shipped on the earlier Peerless, while Wichel House expected it to arrive on the later Peerless. When the cotton arrived on the earlier ship, Wichel House refused to accept and pay for it. Please, do you understand the case? Oh, none of you understand the case I've just read. It's an interesting case, very interesting. And I'll probably use another scenario to make you understand the case. Oh, somebody is giving a thumbs down. Who is that now? Augustine Akoli, you don't understand. Oh, but this is English now. Let me read it again. It says, they entered into a contract for the sale of cotton. So one is buying cotton from the other. But the cotton was going to be shipped from one country to another, right? So from Bombay to Liverpool. Okay. Now, in their agreement, they specified that the name of the ship that was going to carry or transport the cotton was Peerless. But unfortunately, there were two ships that had this same name, Peerless. Okay. But the ships were not going to depart at the same time. Probably one was going to go this week, the other will go next week. But they had the same name, Peerless. And so what happened is that Raffles intended, that's one of the parties, intended the cotton to be shipped. So Raffles was the one who was going to sell the cotton to Wichel House. So he intended that the cotton will be shipped on the earlier Peerless, which is the first ship that will go. But Wichel House, that's the buyer, was also expecting that it is the second ship that will bring the cotton. So when the first ship got to the destination, Wichel House said, no, this is not the cotton I'm expecting. I'm expecting the cotton on the next ship. So he refused to pay, or he refused to accept that cotton and pay. And of course, Raffles sued that we have agreed that you buy cotton, I've sent the cotton, and now you are telling me you not pay because you were thinking that it will come next week or it will come later. Please, if you are sitting in the in the courtroom as the judge, what will be your verdict? Would you compel Witcher House to accept and pay for the cotton? Yes, Prof. Na.
Yes, I would, because they are all ships and it's the same PLS. Like, just accept it and pay if you don't want it to. Because right now, that's the only thing you can do. Yeah. Unless maybe there was some, like, maybe the ships had their own problems. That's why
Okay.
he decided to, he was expecting the later one. Yeah.
Yeah, that is nice
Apart from
verdict.
that,
Let me hear from our guest and Akoli, and then I'd want my professors like Rama and Nadum to share their view on this one since they followed the case. So, Augustine, let me hear you.
Sir, please, no. Oh.
Yeah, Augustine, I'm listening. You said no because.
Sir, please, because it's a contract, and if people agree that you want to buy cotton, so because I am the because I am.
I think lawyer Judge Augustine is gathering his. Can I hear from Nadum? Nadum, what will be your verdict on this case?
Okay, sir, please, sir, please, I'm coming. Okay, please give me time. Sir, please, from what I understood from the case,
Yeah.
is that it was agreed that the cotton will arrive on a ship called PLS, and if the ship arrived and the name of the ship is PLS, and it arrived with cotton, then I don't know how to pronounce the name, but then
Witcher House.
Witcher House should pay for it, because it was stated that it will arrive on a ship called PLS, and a ship called PLS came. So should, in case the second ship doesn't come, he has gotten it from the first ship. That's
okay. Great. Thank you for that verdict. Let me hear lastly from Rama. Prof. Caleb, I would have loved to hear you on this one, but let me hear from Rama Amoa, my namesake. Okay, Bright. Is it Bright whose hand is up? No, Augustine. Okay, Augustine has spoken already. So, Rama, can we hear you on this?
Sir, please, I'm coming. I just joined like 5 minutes ago.
Oh, okay, sorry. Okay. So I think you can read and then maybe give us your verdict. Prof. Caleb or Jeremy? Whoever is ready to share his thoughts on this one. Okay, so interestingly, I think you are itching to know what the court said. Well, the court said that, you see, there was a fundamental breach of the element we just looked at, and that is meeting of the minds or the consensus or mutual assent. So the court said that, well, in your agreement, you said a ship called PLS will bring it, but did the two of you agree that it was PLS 1 or PLS 2 that was going to do the delivery? Okay, so Witcher House, of course, was given the verdict, and Raffles lost because the court determined that they didn't agree on a very essential matter. Because if the ships are two, one can assume that, okay, it's ship one that will bring it or ship two that will bring it. And the person has every right to think that way or assume that way. So to avoid the confusion, they should have agreed that, oh, it is the first PLS that will transport the cotton. So meeting of the minds mean that the two parties have to agree. There should be no doubt so that people will assume that, okay, it's A or B. An example is like, for example, you are in school and then let's say your father says, oh, your uncle will bring you money, right? Meanwhile, this your uncle, he's a twin. Both of them have the same name. And he says, oh, Kojo will bring you money. Now you are in school and the first visiting, the Kojo came and there was no money. And then you call your father and say, daddy, because of what you have done, I'm taking you to court. You said Kojo will bring the money. Kojo didn't bring. Meanwhile, your father also intended that it's the second uncle Kojo who will bring the money. So if you take it to court, the court will ask you, did the two of you agree on the specific uncle Kojo that will bring the money? If the answer is no, then of course, you cannot enforce that your father should settle or should, give you some reward or, some damage or compensation. No. So that's why the meeting of the minds, some people are arguing in the chat. Somebody is saying that what? So the company has wasted their money. Of course, they have wasted their money now. But you see, even though the court has ruled, sometimes when it is appealed, they will say that, well, by you too, the curtain has come. So what is your problem? Or they can tell the Raffles to wait, because if the person says he's expecting for the second one, let the second ship arrive, take the curtain and go and give it to him. Okay. But the court deals with law. So they will apply the law and say, because there was no meeting of the minds on the particular PLS ship that was bringing the curtain, the case is the contract cannot be enforced. Okay. So you see that it's interesting, that is law for you. So the court ruled against Raffles, the plaintiff, that no, you cannot enforce the contract because you people did not agree. Please, those of you in the chat, ceasefire. We are not in the courtroom. Bring your courtroom to our discussion. Bright, Na, and Augustine. Okay. But if you have questions, please ask. You think the court didn't rule fairly? But it's interesting, it will shock you that some of you have been doing this. Yes, Augustine, let me hear you.
Say it's
Oh, Augustine, it seems, I don't know if it's my network or yours, but I can't hear you well, Augustine. Please, other professors, can you hear me?
So the court did it fairly, like they would fairly.
Okay,
Yes,
okay,
please.
okay. So you think the court ruled fairly, eh? Yes.
Yes, sir.
In fact, it is true. You see, sometimes somebody will say, oh, I'll sell my shoe to you. Okay. You are there, then the person will bring it, and then you tell the person, but we didn't agree that you should bring it now. I thought you would bring it next week. That is why meeting of the minds is very important on the essential terms. You have to agree on the terms that let's do this. So, yeah, I think Irama has a question. Irama, let me hear you.
Okay. Sir, please, I want to ask why Witcher House refused to accept and pay for it. I don't understand.
Yeah, because you see, one of the key terms of a contract is that you have to agree on all the essential terms. So if you are going to sell cotton to somebody and you are going to ship it, now, I don't know how coincidentally the two ships had the same name. So it's like one ship was going to move, let's say January, and the other ship was going to move February. Now, Raffles, who was doing the transportation or who was sending the cotton, put it on the first ship, which was going on in January. Meanwhile, Witcher House, the buyer, was also expecting that it is the second ship that will come in February. So when the thing got there in January, he refused to accept and pay because he was also expecting the next one in what? February. So then Raffles, the seller, sued him that he has to accept and pay. Okay. And he also argued his case out that, well, we didn't even agree whether it was the January ship or the February ship that was going to bring the cotton. And based on law, the court ruled that, yes, since the two of you didn't have that mutual assent, that it is the ship coming in January that is bringing the cotton, this cannot be enforced. The court cannot grant any remedies to this case. That is why Raffles lost the battle, or Witcher House was not compelled to accept and pay for the cotton.
But it's all cotton.
Yes, it's all cotton. Let me let me give you an example. Let's say you are in class and you ask your friend to buy you a pen. Then your friend, you didn't agree. Both of you didn't specify. You neither told him or her to buy you blue or black pen. Neither did he or she also ask you to buy you blue or black pen. Then he goes and come and bring you black pen. Then you say, I don't like black pen. I want blue pen. If you take it to court, it will be ruled that since the both of you did not agree on the type of pen, even though you say they are all pens, but since both of you did not agree on the color of the pen, in fact, the court will not rule for anybody because there was no mutual assent. So it's very important when you are entering into contract, make sure that the both of you agree on, in fact, the most important terms of the contract. Otherwise, you lose the case and you think that the court is not fair. So the example I gave you, I think you can appreciate that your friend cannot force a black pen on you because you needed blue, right? And he's bringing black, and because he says he should buy you pen, so he has brought it and you should buy it. No. Okay, so you assumed you want blue, he assumed you want black. Now there's a conflict. Okay, what is the way out? To be fair, the question will be, did you say you want blue pen? If your answer is no, they will ask the other person, did he or she tell you he wants blue pen? You say no. So why did you give him black? And because I didn't know he wants blue pen. You see, then you begin to give excuses. So for me, I think the court was very fair with this one. Okay.
Okay, thank you.
Yeah. But I think you also now agree. Yeah, Josephine.
Sir, please, I have a question.
Yes.
So, does it mean that the Rachel House didn't pay the money?
In fact, because Raffles sued him, okay, because if you sue somebody, it means you want to compel the person to act or not to act or refrain from acting. So Raffles sued him for him to accept and pay the cotton that has arrived. And he also wanted to show that, well, no, because we didn't even agree what ship is bringing what. Okay, so the court ruled against Raffles that you cannot compel Rachel House to pay. Well, after the court case, I'm sure maybe they will meet somewhere and agree that, well, after all, it's the cotton I wanted. So, but in the court, the decision was that Rachel House cannot be compelled to accept and pay for the courting, because in the contract there was no agreement specific on which of the peerless ship was bringing the courting.
Thank you, sir.
Okay, thank you too. Now let's go to the next element, which is intention to create legal relation. Intention to create legal relation. So we are saying this is also another element that is considered when you have a contract with someone. Okay. Now it says that the parties to a contract must explicitly or implicitly make their intention known to each other for the contract to be enforceable or legally binding. By declaring their intention, each party allows the court to enforce the contract and uphold their obligations in case of a breach. In business transactions, the intention to create legal relations is generally presumed, whereas in social or domestic arrangements, it is usually not. For example, promises made between family members, such as husband promising his wife a birthday gift, typically do not result in a legally binding contract. Professors, what this element is saying is that if you enter into agreement with someone, you have to consider if it is a business-related agreement or engagement, then please, that one, it is automatically binding legally. But if it is a social or domestic arrangement, like you and your friends, you are going for a party, or you and your brother, those are considered social or domestic, engagements. And whatever agreement you have there do not necessarily, bind you legally. But in business transaction, for example, you walk to Melcom to go and buy a shoe, then you think you can go and play there. No. For business transactions, the intention to create legal relation is generally presumed that, yes, you intended that it should be binding on you. But for social and domestic arrangements, it is not. Unless in that social or domestic arrangement, the parties, as stated here, explicitly or implicitly stated that, oh, as for this promise, you can take me to court if I don't do it, or I'm serious about it, you can enforce it. So that is for this element. Now there was a case, an interesting case. Mr. Balfour was a civil engineer working for the government in Ceylon, now Sri Lanka. Okay. During his leave, he and Mrs. Balfour, so his wife, returned to England. Mrs. Balfour had developed rheumatic arthritis and was advised to stay in England because of her health, or for her health, right? Interesting. Somebody and his wife, they went on a holiday, and then the wife developed some illness and couldn't return because she had to stay there. Now, Mr. Balfour was about to sail back, as he was about to leave back to Sri Lanka. And he promised to send Mrs. Balfour £30 a month until she could return. They later drifted apart, so there was a separation or divorce, if I should say. And Mr. Balfour wrote to Mrs. Balfour suggesting that they remain apart. Mrs. Balfour sued him for the monthly payment, okay? And interestingly, initially she had the court ruling in her favor, but later it was appealed and the court ruled against her that this was a domestic arrangement. Your husband and your husband and wife making promises to each other and want to take it to court, then I think majority of husbands and wives will be in the prison. Because you say, oh, give me your 50 cedis, I'll pay you tomorrow, and it never comes. So in domestic or social, as in friendship, and family related matters, the court does not really pay attention to most of the things, unless the parties, explicitly or implicitly states that it should be binding on them. Please, does it make sense? Or there's confusion? Professors. The law is making your head bust because you feel that, but if the husband too says you pay the 30 and he's not paying, why shouldn't he pay? Well, the court ruled that yes, this is a domestic, engagement, and Mr. Balfour did not have any intention that it should be binding on him like that. Okay, after all, he made a promise, okay, to send the 30 pounds. Okay, and I'm sure Mrs. Balfour wouldn't have had any problem with Mr. Balfour not sending the money until they, divorced or drifted apart. Okay, so the court ruled that, well, this is a domestic engagement and it has no intention to be bound legally, or Mr. Balfour had no intention to be bounded legally by it. Because you are my wife now. Okay. So that is why your father can promise to, take you to an excursion. And if he fails, you cannot sue him, because even if you sue him, you will not win because he is your father. Okay. Now, the last element we'll look at before we round up today's discussion is certainty of terms. Certainty of terms. Now, we say that certainty of terms refers to the clarity of a contract's terms and conditions. The terms of the contract must be clear, certain, and unambiguous. All essential elements such as price, quantity, quality, and timing must be specified. This supports the mutual assent or consensus in the contract agreement. So certainty of terms, as stated here, has a bearing on the issue we looked at between the Raffles and the Whicher House, that there should be a consensus or mutual agreement on the terms. Here we say the terms should be clear. You have to be clear. You have to give detail. In fact, every little detail, you have to give it. That's the certainty of the terms. There should be no doubt in the party's mind. For example, you are selling shoes to somebody, and then you say, oh, the shoe is 10. If you say 10, is it dollars or Ghana cedis? So if you don't add the specific currency and the person refuses to pay, you sue the person, they'll ask you, that 10, what is it? Because it's ambiguous when you say 10. 10 what? So certainty of terms. The terms must be clearer. Please, any question? Okay, so let's look at the case between these two, and then I think Scammell and Austin. So Austin agreed to buy a van from Scammell, and in exchange to trade in an old van and pay the balance on hire purchase terms. The contract did not specify the details of the hire purchase terms, such as the duration, the interest rate, or the total amount payable. Scammell and Austin later disagreed on these terms, leading to a dispute. I think this is clear. The court will not even waste time. The issue is you enter into agreement with someone and you didn't, specify or clarify the terms. You ask your friend to buy you shoe and you don't give the person the color, the size of the shoe you want. Then the person brings anything. And then you sue the person. Well, it will be ruled that you didn't specify, the terms were not clear. So both of you have no case. Okay, so that is about the certainty of terms. Professors, I'll pause here if there are questions. If there are no questions, like I told you, I have a case study for us. A case study for which individually you read through and apply all the understanding you've gotten from the elements of a contract as I've discussed here. So any question? We've looked at offer and acceptance, the consensus or mutual agreement or assent, intention to create legal relation, and certainty of terms. And for each of these elements, there are cases for each of them. So if you are making arguments in your case, you can quote some of the cases, okay? In the case of offer and acceptance, you can talk about the Taylor versus lied, right? Please add the year so it makes you score more points. Taylor versus Laird, 1856. Hyde versus Range, 1840. And that specifically looked at counter offer, right? Then if you come to invitation to treat and offer, we have Pharmaceutical Society of Great Britain and the Boots Cash Chemists Limited. And then for consensus or mutual assent, we had the case of Raffles versus Wichel House. Intention to create legal relation, we have Mr. Balfour versus Mrs. Balfour. The case was Balfour versus Balfour, 1919. And then certainty of terms, we have Scammell versus Alston, 1941. Okay. Please, any question at this point, professors? Any question? No questions? Oh, please ask me questions. Oh, Professor Tina. No question for Mr. Amo. Okay, if there are no questions, I think we'll finish the class in the last session. So you go back to the first session details, okay? And I'll present the case. We'll read it together, read the questions, and then I'll leave you to go and answer it and submit. So let's meet in the final session. Please, I have 16 professors here. All of you should come. Don't say because I said, hey, case study, so I'm running away. If you run away, I catch you. If I catch you, I'll buy you a toffee. A toffee in a knock form. Okay, so let's meet in the final session.